charged the offense of conspiracy to defraud, contrary to Section 393 of the Penal Code, and particulars are that on or before 2nd October 2023, at an unknown place within the Republic of Kenya, joined with another before court, conspired together to commit a felony, namely stealing an amount of 110 from Kenya Commercial Bank. The second count is the offense of stealing, under Section 268(1), as read with 273 of the Penal Code, that on 2nd day of October 2023, at KCB Bank Malindi branch within Kilifi County, jointly with another before court, you stole 201,110 from an account given here in the name of Mwalimu Bakari Mwadama, the property of Kenya Commercial Bank. You heard what the witnesses said. I think I can go straight. Section 393 of the Penal Code states, any person who conspires with another to commit any felony or to do any act in any part of the world which, if done in Kenya, could be a felony, and which is an offense under the laws in force in the place where it is proposed to be done, is guilty of a felony and is liable, if no other punishment is provided for, to imprisonment for 7 years. Or if the greatest punishment to which a person convicted of a felony in question is liable is less than the imprisonment for 7 years, then to that lesser punishment. The meaning of conspiracy is defined in Criminal Law Act 1977 of England, which defines it as follows. It is a situation where a person agrees with another person or persons that the course of conduct shall be pursued, which, if the agreement is carried out in accordance with their intentions, either will necessarily amount to or involve the commission of an offense or offenses by one or more of the parties to the agreement, or could do so but for the existence of facts which render the commission of the offense or of the offenses impossible. So the essential ingredient of this offense is that two or more people must agree to put into effect a scheme whose ultimate aim could be the commission of a criminal offense. Now, the core element, therefore, in this one is the consent of two or more persons. In other words, there must be a meeting of mind between two or more, but not one. Whereas there is another file, according to this evidence, there was another file where another person was charged with the same offenses as this, which faces the accused person. We were told, but these files were never filed in court for the court to confirm that indeed in another case where one Kiruyot Langat was also charged with a similar offense. Now, without a link between the two, the law is clear that one cannot commit an offense against himself. There was need to have Kiruyot Langat as a witness in this case, or documents to show that there was a link between the accused in the dock and Kiruyot Langat. This was not availed. Now, under Section 268, it relates to the offense of theft. So, having also gotten and with what theft is, the investigation officer was very categorical in his evidence that the data that they retrieved from the numbers that were used did not disclose any number of an accused person to have been involved in the transactions which are alleged to have been committed. There was no evidence also, according to the investigation officer, that the accused ever received part of the spoil that was taken from KCB Malindi branch. In disposal, this case has not been proved beyond reasonable doubt with the accused person.